But one of the things that I wanted to do is start by reading the mission of the Federalist Society. When we were here last together in October, when Chief Justice Muniz was here, there was some confusion about what the mission of the Federalist Society is and who is invited or who participates in FedSoc membership. So I wanted to get on the record and make sure that that's not an issue anymore. The Federalist Society's main purpose is to sponsor fair, serious, and open debate about the need to enhance individual freedom and the role of the courts in saying what the law is rather than what they wish it to be. We believe debate is the best way to ensure that legal principles that have not been the subject of sufficient attention for the past several decades receive a fair hearing. The society is about ideas. We do not lobby for legislation, take policy positions, or sponsor or endorse nominees and candidates for public service. Beyond our statement of purpose, the Federalist Society takes no public policy positions and does not participate in activism of any kind. We focus on fostering debate and discussions of important legal topics. We do not wish to speak for our members, and neither do our speakers. This has been true since our founding in 1982. So everybody's welcome. Everybody continues to be welcome. And I really appreciate two academic heavyweights giving the issue that we're going to discuss tonight serious conversation. So I want to turn it over to Catherine Urbanek, who's on our local FedSoc leadership team. Catherine, about a year and a half ago, I got an email on a Saturday morning, and she says, hey, I'm here in Jacksonville, and I was the law student president at Pepperdine University. And I'm thinking, wow, California, FedSoc, young woman. It's great to have diverse perspectives, and I want to get Catherine involved. So this was her idea. She gets all the credit for setting up this awesome panel, and I'm glad she's here. She's now a clerk in the new 6th District Court of Appeal for the Honorable Joshua Mize. Catherine, I'll turn it over to you to introduce our panel. Thank you so much.
I will start off with Professor Danaya Wright. Danaya Wright received an AB in English from Cornell University, an MA in English from the University of Arizona, an MA in Liberal Education from St. John's College, a JD from Cornell University, and a PhD in Political Science from the Johns Hopkins University. She joined the faculty of the University of Florida Levin College of Law in 1998. One of Professor Wright's principal areas of research is on the origins of English family law, particularly 19th century reforms in the area of child custody and divorce law. Two of her articles in the area of 19th century family law reform were chosen best papers at the first and third Stanford-Yale Junior Faculty Forum competition for young scholars, and another article won the Donald Sutherland Prize for the most significant work in English legal history from the American Society for Legal History. She is currently writing a book on the history of judicial interference in the family and constructions of public and private patriarchy. Besides her work in English legal history, Professor Wright's other scholarly interests are in 19th century property rights of railroads and the conversion of abandoned corridors to public use recreational trails. She is one of the leading experts on rail trail conversions and is frequently asked to give expert testimony in critical rail trail cases and to assist in writing appellate briefs in the area. She has also written numerous articles and provided testimony on the Equal Rights Amendment and other constitutional law matters. Her constitutional law scholarship has been cited by the Supreme Court and numerous lower courts. As chair-elect of the University of Florida Faculty Senate, she is busy researching issues of academic freedom, post-tenure review, and censorship. She is an affiliate faculty member in the History Department and Center for Women's Studies and Gender Research, and in 2010 through 2011, she was a visiting professor of law at the Georgetown University Law Center. You both have very long bios. I can't, I don't want to, yes, but I was just, all of this is very impressive, so I didn't want to skip on anything. Okay. Professor Robert Pushaw earned his BA from LaSalle College 1980, graduating summa cum laude, and his JD from Yale University in 1988. In law school, Robert Pushaw served as notes editor of the Yale Law Journal and received an Olin Foundation Fellowship. After graduation, he clerked for Judge James Buckley of the U.S. Court of Appeals for the D.C. Circuit, then worked as an employment lawyer for Davis, Wright, Tremaine in Seattle. Joining the University of Missouri School of Law faculty in 1992, Professor Pushaw taught constitutional law, federal courts, and contracts. In 1998, he won the Blackwell-Sanders Distinguished Faculty Achievement Award as the law school's top teacher. In 2000, Professor Pushaw received the William Kemper Fellowship for Teaching Excellence, University of Missouri's highest teaching honor. He came to Pepperdine in 2001 and won the School of Law's Annual Teaching Award in 2007. Professor Pushaw's scholarship studies the influence of 18th century Anglo-American political and legal theory on the development of the modern law governing the Constitution and the federal courts. Professor Pushaw is a prolific author. His scholarly writings have appeared in the Yale Law Journal, Michigan Law Review, California Law Review, Cornell Law Review, Northwestern University Law Review, Georgetown Law Review, Notre Dame Law Review, Iowa Law Review, University of Illinois Law Review, lots of law reviews, I'll just put it that way. At the University of Missouri, he twice earned the Shook, Hardy, and Bacon Excellence in Research Award. At Pepperdine, he received the Dean's Award for Excellence in Scholarship in 2017. Professor Pushaw served as Associate Dean for Research and Faculty Development from 2012 through 2015. He is the Faculty Advisor for the Pepperdine Law Review. So on that note, I will hand that over to our speakers.
Do you want me to go first?
Yeah, you have to go first.
Okay.
Because you invited me.
Yes. I'm going to make a claim that among constitutional law professors is considered outlandish, which is the Supreme Court actually got Dobbs right in reversing Roe v. Wade. I think the majority of the justices correctly ended what I consider a futile quest. They've been trying to find a right to abortion lurking somewhere in the Constitution. They've talked about the First Amendment, the Third Amendment, the Fourth Amendment, the Fifth Amendment, the Ninth Amendment, the 14th Amendment. I think whatever your political or ideological views, the court's legal reasoning in Dobbs was sound. So let's start with the Constitution's text, which says nothing about abortion. If you turn to history, no one who wrote or ratified the Constitution said it included a right to abortion, nor did anyone who implemented the 14th Amendment from 1867 for about a century. Relatedly, abortion is not one of those rights that is implicit because deeply rooted in American history or traditions. On the contrary, again, since 1867, no state law recognized such a right until a few states started to do so in the 1960s. And finally, the Constitution has a democratic and federalist structure which leaves deeply contested social, moral, political, cultural issues to state-by-state political process, and that includes abortion. So really in Dobbs, the only legal argument for upholding Roe and Casey was that they had been decided. Stare decisis, court should stick to its precedent. Well, many of the justices have noted that stare decisis is actually at its weakest in constitutional cases. Why? Because first of all, the court is bound by the Constitution. Secondly, it has a special duty to rectify its previous misinterpretations of the Constitution because it's almost impossible to reverse a Supreme Court decision by constitutional amendment. That's only happened 3 times ever. So the court has frequently overruled precedent that was clearly wrong, badly reasoned, and having negative practical effects, Brown v. Board of Education being the most famous example. I think Roe and Casey are examples of reversible precedent. So Roe built upon Griswold v. Connecticut, in which the court created, I would say invented, a right to privacy that included the use of contraceptives. Then in Roe v. Wade, the court said the right of privacy was based on the word liberty in the Due Process Clause, and so this privacy encompassed a woman's decision to have an abortion in consultation with her doctor during the first 2 trimesters of pregnancy when the fetus was not viable. Now, even though the court, I mean, if you think of fundamental rights as like free speech, freedom from unreasonable search and seizures, court said, well, we just made up this right to abortion, but we're going to deem it fundamental. which means that state laws regulating it would be judged by the most rigorous standard of review, which is strict scrutiny. How bad was Roe's constitutional analysis? So bad that even pro-choice legal scholars like John Hart Ely criticized it. Most importantly, Ruth Bader Ginsburg herself conceded that Roe was legally unpersuasive. She said the court really should have ruled that abortion restrictions violated equal protection clause rights of women. What happened? Well, by 1992, you had 5 Republican appointees, so it looked like Roe would be overruled. Surprisingly, 3 of those Republicans, Kennedy, O'Connor, and Souter, they acknowledged that Roe was wrongly decided. It was based on a misinterpretation of the Constitution. 2 of them had actually said that in opinions. But they said, gee, well, if we overrule Roe, Americans will perceive us as caving into political pressure. So these justices they basically reaffirmed the basic holding of Roe. They said women have a right to abortion, but they threw out the doctor-patient privacy rationale. They threw out the trimester framework, and they threw out strict scrutiny. So it's kind of a weird approach to start. You reaffirm a case, but you gut its reasoning. So what they said is, well, we're going to give states more leeway by holding that states could discourage, but could not unduly burden a woman's abortion choice before viability. Now, in Casey and in Roe, the court never explained why fetal viability, which at the time of Roe was 24 weeks, it's moved back to about 22 weeks. But they never explained why fetal viability was the critical line rather than, say, conception, or in the common law was quickening when the fetus first moved about 16 weeks. And again, what Casey did with stare decisis, to put it charitably, was kind of novel. You purport to reaffirm a decision, you rewrite big chunks of it, and you engage in what is basically a political compromise. Moreover, the court simply dreamed up the undue burden test. That was found in no prior decision. And undue burden is utterly subjective. What's the difference between an undue burden and a due burden? I don't know. Nobody really knows. And so what happened after Casey is you had 30 years of cases which illustrated that this was just hopelessly subjective. For example, 5 justices held that a state law banning late-term partial birth abortions unduly burdened a woman's right to choose, whereas 4 justices said states could surely ban a procedure that mimicked infanticide. So I think the majority in Dobbs, the opinion written by Alito, convincingly argued that Roe and Casey lacked any foundation in the Constitution and should be overturned. By contrast, the dissenters in Dobbs thought that Roe and Casey should be upheld because they reached the correct result. The dissenters said the court properly identified a right to abortion because the Constitution is a living document and the justice can interpret it flexibly to account for changes in society, most obviously a growing recognition that women were equal citizens with autonomy, and they can control their lives, including their reproductive lives. The dissenters also emphasized that stare decisis promoted stability and protective reliance interests, so that they made a point, which is every woman of childbearing age in America has grown up in a world in which abortion was a constitutional right. To be clear, I can't really tell you whether the majority or the dissent was correct on stare decisis. It really depends on whether or not you think Roe and Casey were egregiously wrong. That in turn depends on whether you think the Constitution is a fixed law or whether 5 or more justices can legitimately construe its words creatively to reflect what they consider to be evolving social norms. I also wanted to just briefly highlight a couple of concurring opinions. First, Chief Justice Roberts would have reaffirmed the basic constitutional right to abortion Yet he asserted that right could be preserved as long as women had a, quote, reasonable opportunity to make that choice. So the law issue, Mississippi banned abortion after 15 weeks. Robert said, hey, if you're a woman, you're 15 weeks pregnant, you know you're pregnant, you have a chance to get an abortion. That was preserved. But he said the time did not have to be extended to the point of fetal viability. So he said 15 weeks was fine, didn't have to extend it to 22 or 23 weeks. It's kind of sad. It's kind of sad for Chief Justice Roberts. No one joined his opinion. No one. I mean, imagine if Marbury versus Matt, Chief Justice Marshall wrote the opinion for Chief Justice Marshall. It's really quite unfortunate. But I think that the dissenters realized he had butchered Roe and Casey beyond recognition. The holding hinged on viability. That was the line. Roberts said, oh, that was dicta. I mean, I don't know what that means anymore. The majority viewed his opinion as a nakedly political compromise with no constitutional basis, which it was. Now, I think that the second and more intriguing opinion was by Justice Thomas, right? So Thomas argued that the due process clause is about procedures that the government has to follow before they deprive you of your liberty. So Thomas contended that the clause does not confer any substantive rights, and the court for 170 years has been making up rights, and that the whole thing was illegitimate policy making. For example, the origin of substantive due process is Dred Scott v. Sanford, where the court held that slave owners had a due process, liberty and property right to bring their slaves into any Western territory, even if Congress had prohibited it. We then fast forward to Lochner, 1905. The court ruled that liberty was freedom. That included freedom of contract, so states couldn't enact most progressive legislation like minimum wage and maximum hour laws. The court, in my opinion, and in Thomas's opinion, properly repudiated substantive due process in 1937. But then they resurrected it. I mean, substantive due process, like the old horror film Carrie. She's buried, then her hand comes up, and it's like federalism. It just, the court keeps burying it and it keeps popping up. But in any event, so in Griswold, the court creates this new right to privacy, and then the court extended that right to include abortion in Roe v. Wade, and then to include sodomy in Lawrence v. Texas in 2003, then same-sex marriage in Obergefell in 2015. Now, what's interesting is the dissenters in Dobbs agreed with Thomas. They said, well, if the court overruled Roe, that logically called into question cases upon which Roe rested, like Griswold, as well as later cases that build upon Roe, like Lawrence and Obergefell. So all those cases stress that Americans had personal autonomy to make private, intimate decisions without government interference. But the majority strenuously denied those cases were in jeopardy. They said they're categorically different because only abortion raises the profound issue of taking a human life. That may be true, but that is a matter of fact. That is not a matter of law. That was Thomas's point. There's no legally principled reason to overrule Roe, but not the rest of its associated jurisprudence. Nonetheless, I believe that realistically those precedents are safe, but for totally non-legal practical reasons. So take Griswold. Very few people want contraception to be banned. Lawrence v. Texas, by a huge margin, Americans object to governments invading the bedrooms of consenting adults. Obergefell, since 2015, there have been hundreds of thousands of same-sex marriages that have been legally entered. So I think as a practical matter, it would be impossible for the court to nullify such matters. The reliance interest is too great, particularly when these same-sex couples have adopted kids. So consequently, if you read the majority opinion in Dobbs, they repeatedly insist, we have a sworn duty to enforce the law of the Constitution. We can't worry about public opinion like those sniveling wimps did in the concurring opinion in Casey. They didn't put it in exactly those terms, but I think at some point, public opinion matters. Americans are going to rebel if too many popular precedents are overturned. And that tells me the conservative justices are really in a bind, right? They are trying to explain what the Constitution actually says, but politicians and the media and Americans generally care only about results. Who reads Supreme Court opinions? I don't think there's 100 people who have read Dobbs cover to cover. And people have become accustomed to the court interpreting the Constitution according to their political and ideological views. That's why there's such fights whenever there is a Supreme Court vacancy. So even what I consider a legally principled opinion like Dobbs is assailed as just naked partisan politics. It's very hard for me to see a way out of that conundrum. So we will see what happens. Thank you. I'll turn it over to Professor Wright, who I think has a slightly different view.
Slightly different view. Thank you, Bob.
Yes.
So I do have to say, obviously, I'm here because I think the court got it wrong in Dobbs. I think you're wrong, Bob.
Okay.
Thinking it was right. But I'm gonna try to explain a couple of. I have a lot of points I want to make. My head is just sort of generally swimming with lots of ideas about this. But the most common argument about Dobbs is, or about abortion generally, right, is the weakness of this shaky foundation of substantive due process. So the idea was, back in the 1890s, the court elevated substantive due process rights. They fundamentalized economic rights. And finally, by 1937, thanks to economic meltdown and a lot of people losing their lives and pretty much utter disaster, the court backed away from that. And I think it's important to realize that it was a very conservative activist court during that period that elevated this substantive economic due process right. And the consequence of elevating the right was that actually employers could refuse to collectively bargain. Hammer versus Degenhardt, which I don't know how anybody can accept Hammer versus Degenhardt, was the case that said Congress does not have authority, frankly, nobody has authority, in essence, to regulate and restrict child labor. So you have cases, maximum hours, minimum wage laws were stricken in ways that caused very real harm to people, very real consequences in people's lives. And so when the court was finally, whether it was the switch in time, the Save 9, the court packing plan, whatever it was that caused the court to finally back away from that notion of substantive economic due process, what happened was that now government, we got big government. We got big government. Government could go in, it could regulate, it could stop things like child labor practices. It could insist that people had the right to collectively bargain. And so there was a retrenchment of rights, but the retrenchment was the rights of the big economic interests, big business that didn't want to be regulated. And what happened was the little people got better protections. And I think it's important that 1965 comes along, Griswold comes along, and the liberals do exactly what the conservatives just got their hands slapped for doing. They got in trouble. They eventually had to back away. They all said, mea culpa, I didn't mean, we're sorry, we didn't mean to elevate economic rights to this level. We were wrong, we're sorry. Yes, we melted down the economy. Yes, we understand that was not what we were supposed to be doing. And then the liberals turn around and they do the same thing, right? They do the same thing. And in Griswold. And how can anybody sit there with a straight face and say, how come you get to do it, but we can't do it? And I do believe that actually, the sort of the shaky foundation of due process in 1965 with Griswold, it left a bitter taste in the mouths of a lot of conservatives who felt that, wait a minute, if we can't do it, you don't get to do it either. So that's part of the problem. But there's a way, though, in which when we think about substantive economic due process, reversing it means we're going to remove a lot of the harms that had come about as a result of elevating these economic rights. So now we don't have child labor, except we actually do, but it's over in the, as we've just discovered, thanks to the New York Times, it's a lot of immigrant children, unfortunately, are being forced to work. But the idea was reversing the substantive economic due process cases resulted in a reduction of harm in people's lives. The substantive due process that then gets resurrected by the liberals, and it's liberal activism, I absolutely agree, that creates a situation where people have more individual rights. So whether it's contraceptive rights, and I'm going to leave abortion to the side for the moment, but all of the other rights, my exercise of a right to engage in a same-sex marriage or a same-sex sodomy does not harm you. It doesn't harm anybody, right? And so I do think there's a profound difference between the substantive economic due process cases of the turn of the 20th century and the substantive due process cases, I get my tongue tied on that, of the Griswold and post-Griswold era. Because increasing and improving and protecting rights, individual civil liberties, does not inflict harm. It doesn't hurt anybody if people have a right to contraception, right? But it does hurt people if manufacturers have the right to engage in child labor practices or unfair labor practices or a lot of those things. So I think there's a difference, and I get tired of listening to the critique from the right that says, yeah, but due process is wrong, right? It's this shaky foundation. And I'm willing to say, yes, it's a shaky foundation, but we have a whole lot of other constitutional doctrines with a lot of shaky foundations. And probably the one that really annoys me the most is the regulatory takings doctrine, which is wholly made up. There is absolutely no original justification for that. And yet the conservatives on the court trot that out all the time. And that's really their sort of, oh, well, yeah, we gave up substantive economic due process rights, but hey, we got over here, we got regulatory takings. And so I think there's a difference. So I want to make clear that I agree. This is a shaky foundation, substantive due process. But there's a difference with the latter period of due process rights versus the earlier period of due process rights. And it has to do with the consequences, the real life consequences. So that gets me to Dobbs, right? And I do think if we look at the Dobbs decision, we have to accept that it was not decided in a vacuum, that women are now dying. Women are dying as a result of that decision. And the majority can say, oh, well, or like Kavanaugh, oh, well, we're just neutral. No, you're not neutral. Women are dying as a result of it. Women's lives are being completely fouled up as a result of this. And so there are consequences. And their answer to that is, well, that whole Roe Casey viability test made no sense, right? It just doesn't make sense. But let me ask you this. If you were able to buy a Lexus to drive across the country to Pepperdine, right? And the government told you, no, you have to drive a Ford Pinto. You would say, that's not fair. That's unreasonable. That's irrational. That's arbitrary and capricious because you are forcing me to engage in an activity that has greater risk than the one I want to do. So the thing about Roe that people never seem to, even the liberal scholars have said, oh, that whole trimester framework made no sense. The point about Roe and that first trimester said, because the risk of an abortion is lower than the risk of carrying a child to term, government under a rational basis test cannot force a woman to engage in a riskier activity than one that is less risky. And that just, you know, the way Alito dealt with that particular issue in the decision, I found completely insulting. It's like, oh, well, they said something about risk. It's like, yeah, they did say something about, yes, Roe was about the risk. And if for a government action to pass rational basis scrutiny and force a person to engage in a riskier activity than the one that they choose is, I think, really problematic under any government and any analysis of government. So that's number one. The second one, and I get it. It's very, it sounds really good to say we're interested in life, that the government has an interest in potential life, that this is a compelling interest. Absolutely. So when you take care of, you give me some sensible gun regulations, when you actually enforce a COVID mask or vaccine mandate, I might believe you that you, the government, care about human life. Because clearly the government doesn't care about human life. If they cared about human life, we wouldn't have a 70-mile-an-hour speed limit on our interstates. We would have responsible gun control. We would have funding for our Department of Children and Families, right? So we wouldn't have children dying from abuse and neglect. If we actually cared about human life, we would do something about that. We would have a good healthcare system if we cared about human life. We would outlaw cigarettes and alcohol if we cared about human life. We would create drug safety zones and a needle exchange program if we cared about human life. We might actually take climate change seriously if we cared about human life. So I get, it sounds really good to say, oh, we're protecting the fetus. And I don't want to say, I get it. Every person should be able to make the decision as to what they feel is important in their lives, what human life means to them. But I am not going to buy the argument that government actually cares about human life. So that argument in Dobbs, I just have a really hard time swallowing. And then they say, okay, well, actually what we're really, we're returning this to the people. We're returning the decision about abortion to the people and to the democratic process. And I'm like, that sounds really good. I like that. So tell me now why you decided Rucho versus Common Cause and said political gerrymandering is fine. If you actually care about the political process and voting rights, you wouldn't have decided Shelby County versus Holder and completely gutted the Voting Rights Act. You would not allow Citizens United to allow the kind of money in politics if you actually cared about the democratic process, and people's opinions being represented in the democratic process. So, the voter suppression laws and political gerrymandering that's happening at the local level really makes you question this idea, oh yes, this very pure, abstract constitutional theory, we're returning it to the power to the people, but we're making it almost impossible for the people's views to come out. And finally, this idea about history and tradition. I'm sorry if I'm talking too long. History and tradition sounds really good, due process. The whole Glucksberg test says, the only fundamental rights are those that have a long history and tradition in our legal system, whatever the exact language is. And that which is basically another way of saying the Constitution doesn't change. We're only going to change those rights and liberties that were recognized in 1868 or in 1789. And that's, I have a really hard time with that, right? Because women did not have the vote. Women could not participate in politics in either 1868 or 1789. So what is the tradition? The tradition is the tradition of the white man. It was, African Americans didn't have the right to vote. They had no ability to participate during either of those periods of time. So you tell me it's about history and tradition, but I don't see how history and tradition doesn't reinforce a particular viewpoint that silences a tremendous number of people in this country. And so I read Dobbs and I say, this is a bunch of BS. It's a bunch of arguments that clearly you don't really believe. Because if you really believed it, we would actually do something about human life. We would actually do something about protecting the democratic process. We would actually recognize that history and tradition is incredibly racist, homophobic, and sexist. And so I get that that Roe was based on a very shaky foundation, but I have a really hard time with this opinion. That's my 2 cents worth. So we're supposed to have a conversation.
Well, I would,
you can say I'm wrong.
No, I think a couple of points. I think ultimately it boils down to, if you believe that a fetus is a human life that is distinct from the mother, which I think biologically it's a distinct DNA, distinct heartbeat, et cetera, then I think that the state has a compelling interest in protecting that human life. Even though obviously a lot of the circumstances of women seeking abortions are horrible, but that's the first point. I don't think it's simply a question of woman's autonomy, control over her own body. That would be true if you're talking about, surgery for, a tumor or something. And so I think that there is sort of a denial that the fetus has any moral status. And you quoted Roe v. Wade, which talked about potential life. I think it's a life. I think it's a human life. Whether or not that human life is a person, as that word is used in the Constitution, is a different issue. So that's number one. The other thing is, in terms of history and tradition, what you say is correct. But the framers knew that they couldn't see the future, which is why Article 5 allows for amendments to the Constitution. So I think that is better than having the Supreme Court as a rolling constitutional convention. And a lot of my scholarship in other areas, Professor Wright is correct. I mean, the Supreme Court's doctrine in almost every area you can think of, commerce clause, taxing and spending, campaign finance, First Amendment, you name it, is just a mess all over the place. We actually agree on that.
We do agree on that.
And so, I think that there is a problem because stare decisis does matter. I mean, a lot of cases just keep on getting reaffirmed because that's what the court said in 1893 or whatever. But again, I actually also agree that pro-life folks have to do a much better job in helping mothers with health care and child care and, medical care. I mean, I do think if you're pro-life, you have to think about something other than preventing abortion. And the fact is that after Dobbs, the states that have the most draconian anti-abortion laws also have probably the worst health care for women and children. And so I think that is a point well taken. I actually agree with that. I think as a society, if we're going to be pro-life, and particularly in a state that's going to say you can't have an abortion, then you have to morally do something to care for women and their children. Otherwise, they're just in this horrendous situation. So we actually do agree on a couple of things.
Okay, so that's good. I approve. I would say that, the statistics are already showing that maternal death rate is going up. Women are, it's increased by 62% since abortion restrictions have gone into these states. For instance, Arizona which is an abortion restrictive state, a woman is 4.5 times more women are dying in Arizona than in Illinois, pregnant women, due to pregnancy-related problems. That are pretty directly tied to the lack of doctors, because doctors are afraid. I just had a conference on this at UF last week, and we had a couple of doctors in the room who said, long-standing obstetrician and a new obstetrician, and they both said, a woman shows up at the emergency room and she's presenting, and she's bleeding. We need to do something for her. But we can't, because we don't know if it's a miscarriage or if it's a botched abortion. And we don't know, we can't, our licenses are on the line. Our lives are on the line. And this idea that somehow we can separate out abortion provision in the medical health care from all of the other aspects of maternal health and reproductive health care. They say you can't do that. You just can't do it, right? And so the idea, and this is something that just keeps me up at night, is in an abortion restrictive state where they have said that you can't have an abortion, a woman whose fetus has no brain or no skull is going to be forced to carry that child to term and then deliver this fetus that will then die on the table in front of her within hours. And that is better than an abortion. So I am very happy to say that yes, indeed, there is potential life. But the problem is at some point, let me say this. The Roe acknowledged and Casey acknowledged that post-viability, absolutely the state can prohibit abortion. It can regulate it heavily, because at that point the fetus can live outside the mother. Prior to that point, Roe said you can even regulate abortion in the second trimester. As long as the risk of an abortion is equal to or greater than the risk of carrying an infant to term, a baby to term, then you can absolutely regulate that. But you should not be regulating any of it in ways that are going to undermine the life of the mother. And a lot of our abortion restrictions now don't have life of the mother exceptions. And really the health of the mother. They gave all sorts of examples that were just horrific of inability to provide proper care. So I agree with you. If we can get a lot better services and a lot better support, that's just necessary. But I'm still not willing to accept that in the first trimester, when the risk of carrying an infant to term is greater for the mother, that the state has the right to say that its interest in potential life is greater than the mother's interest. And that's a lot of what the dissent was saying, which, by the way, it's 213 pages, this entire opinion.
Yeah, that's why
It's
nobody
really
reads
long.
it. Yeah, I mean, I actually agree with you that some states are going completely overboard when you are saying, you have an ectopic pregnancy, for example, or the baby doesn't like I think some states are really, or if a woman is in the ER. The other thing is, I think that, morally, ethically, you always have the right to save your own life. You always have that right. I mean, if you're a woman, let's say you have triplets and the doctor says, might be safer to abort one of them, you can say, no, I can't do that. But you're allowed to always protect your own life, certainly, and I think your physical health. One of the problems is Professor Wright said that Roe v. Wade did say and Casey, that after viability, states could prohibit abortion. But the problem is there was an exception for the mother's life. Fine, I agree with that. At any stage of pregnancy, mother's physical health, okay. but then they extended it to emotional, psychological health. And so what happened is women with post-viable fetuses could always get a psychologist, a psychiatrist, to say, well, this is going to cause emotional, psychological harm. So that exception swallowed the rule. And I think, moreover, when states like Nebraska banned partial birth abortion, I think politically the Supreme Court made a tremendous mistake in Stenberg v. Carhart, because at that point in the 90s, you had 5 justices, Bill Clinton was president. He appointed Breyer and Ginsburg, and they said, aha, Kennedy in Casey was going to vote to overrule Roe v. Wade, and he was leaned on and changed his mind at the last minute, wrote it, and so when the liberals on the court needed Anthony Kennedy, he gave them a gift. He said, all right, I'll even though I've said Roe v. Wade is wrong, I'll uphold it, I'll do this, I'll write some gibberish concurring opinion, and we'll save it. And then a few years later, I think bans on partial birth abortion, that to me strikes me as extremely reasonable, necessary. And that was to Professor Wright's point that women didn't have the right to vote. I think abortion bans passed in the 1860s, 1870s, but the Nebraska law was passed in a state where women were half of the electorate, and every woman in the Nebraska legislature voted to ban partial birth abortion, I think that Ginsburg and the liberals on the court said, aha, we're going to say that imposes an undue burden. And Kennedy wrote a dissent and said, no, that's not what I meant in Casey. You got to throw me a bone here. And so I think that the justices, it shouldn't be personal, but I do think that the liberals on the court would have been wise to because there were a lot of pro-choice politicians, starting with then Senator Joe Biden, who said, well, look, that's where I draw the line, at partial birth, late-term abortions. Again, I think that there was this problem when states were trying to ban that. Supreme Court struck it down, and there was always this mental health exception. I'm not saying that mental health isn't important or debilitating, but I just think that exception swallowed the rule. So again, I think that if they had something like a European-style system, which is what Roberts was trying to do, most European countries, it's legislated, it's not judicial fiat. You allow abortion up to 14, 15, 16 weeks, something like that, then it's banned. There's no late-term abortion unless it's a medical emergency. And so I think the Supreme Court just swung way, way too far to the left, and we're now swinging arguably too far to the right, but that's what happens when you have a politicized Supreme Court. And again, I don't feel sorry for the court, mind you. If you politicize constitutional law, you can't then very well complain that, this is a political decision. There have been, after Dobbs, by my count, 76 articles on Dobbs, 74 of which say Dobbs is wrong for the reasons that Professor Wright. I have an article coming out in the San Diego Law Review. It was almost impossible to get it published because law reviews looked at the title, Defending Dobbs, Ending the Futile Search for a Constitutional Right to Abortion, and threw it in the trash can. So San Diego finally agreed to publish it. But the only other person is this guy named Andy Cohn, who's at the University of Arizona Law School. And Cohn wrote a fascinating article. He said, I'm a liberal pro-choice Democrat. But we've been arguing for years that, constitutional law involves moral judgments. That's Ronald Dworkin. And so, the Roe v. Wade and Casey had nothing to do with law. It was a moral judgment that women should have a right to bodily autonomy, a right to abortion, et cetera, et cetera. Why should we be surprised that a conservative court is making a different moral judgment that protecting the human life of the fetus? And he's basically saying, what do you expect? So Cohn at least I'm going out to Arizona actually next month. I don't know what's going to happen to me out there. But again, I have a decidedly minority view which is, I'm getting invitations all over the place to be the sacrificial lamb.
You're holding up just fine.
Yeah. But I mean, and again, I've been writing on this topic for 20 years, and I did write about the partial birth abortion ban acts in particular. But what was interesting is the court said they struck down Nebraska's state partial birth abortion ban, but then a few years later, in a case called Gonzalez, they upheld Congress's federal ban on partial birth abortion. And the only thing that happened that I can see is that Alito replaced O'Connor.
Well, that was a big change.
It was a big change, and so I think that one of the things that is happening, I mean, when I teach constitutional law, especially to first years, believe it or not, I mean, they think I'm an anarchist. Because I'm saying, you have to know the history, the politics of any of these decisions. They go to the dean, they petition the dean because they think I'm a bomb. Some of them think I get accused of being a left-wing anarchist, which is actually pretty interesting for people who actually know me. But, I just say to the students, look, how else can you explain this? I mean, I had two deans, Ken Starr and Janelle Taha, who were federal appellate judges. And on panels, I would say, this is political, and they would just gasp, and they didn't know what to do. And I said to them, look, how do you explain the fights over Supreme Court nominees? Merrick Garland, Neil Gorsuch, makes no difference. Amy Barrett, Justice Jackson, if it's just law, I mean, but I think that the real danger is lawyers have always understood the political and ideological overlay of constitutional law. However, just average people on the street have figured this out, which is why you now have justices like Roberts and Barrett, and like they're coming out, Breyer, saying, it's just law. It's not politics. If you wouldn't have to say that publicly.
Yeah, Kavanaugh's. We're being very neutral here. You wouldn't have had to say that.
Yeah, you wouldn't have to say any of this. And so again, I think if the Supreme Court has been politicizing constitutional law for years, they can't really complain, people are accusing us of being political. Now, having said that, I do want to say that I actually believe that the justices themselves believe that what they're doing is just applying the law to the facts. And so I want to make that clear. I think that the justices, I saw an interview with Harry Blackman, and he said, there's no, Roe v. Wade, it's just the Constitution made me do it. I'm like, can he possibly believe that? But I think he actually did believe that, or I think that you can convince yourself. I mean, the human capacity for self-delusion is amazing. And I think the justices, like when I was looking at Roberts' opinion in the Obamacare case, and my main area is structure, commerce laws, taxing and spending, I've spent my whole career on that. And he's writing this opinion that's just, I think, legally nonsense. But I thought, he was an appellate lawyer, right? He's paid to slice his life. He may actually have convinced himself that this individual mandate was a tax, even though 18 times the Congress said it's a regulation under the Commerce Clause. It's not a tax. President Obama said it's not a tax. Roberts said, it's Commerce Clause, but it might be a tax too. And it's unfortunate for Robert. He's got two major opinions. He's been on the court for 18 years, which was the Obamacare case, National Federation, and Dobbs. And in both of those opinions, he wrote a solo concurring opinion that not one other justice joined. And so that tells me he's trying to broker political compromises. The other justices really now don't care because he's lost the swing vote once Barrett's on the court. I think Barrett and Kavanaugh. And I think he knows that, and so he's trying desperately. But again, I think that what Chief Justice Roberts is doing is bizarre. He's trying to convince Americans that the court is apolitical by writing nakedly apolitical opinions whose legal analysis is so bad that nobody else on the court joins. I mean, I just think that this is crazy. And again, I understand he's the Chief Justice, so he's concerned with the institution of the court. And I think with Dobbs, I mean, to me, what he predicted as a conservative Republican was that if we do Dobbs, we can win this election. We can win the midterms. If we do Dobbs, that gives the Democrats something to grab a hold. It's an emotional issue that I think did have an effect in certain states in the election. But I again, how much naked partisan political maneuvering can you do if you're a justice? A lot.
A lot. So I have a question for you.
Yes.
Because this is something, since you're a Commerce Clause guy, this is something that has just bothered me since as long as I've been teaching Commerce, well, ever since Gonzalez, which I don't remember what year Gonzalez was. But, so Stenberg, the court said, right, undue burden, they struck down Nebraska's partial birth abortion ban.
Some of it would sleep in.
Then we get a federal partial birth abortion ban. And this is the first federal abortion law before the court. And Thomas kind of, in a little aside, says, well, I'm not going to talk about the Commerce Clause issue.
Right.
But they have never talked about the Commerce Clause issue as to whether or not Congress even has authority under the Commerce Clause to pass a restriction of any sort in the context of abortion. And obviously on the broad liberal definition of Commerce Clause, absolutely, because everything goes under, falls under commerce under the liberal view. But under the conservative view of commerce, I don't think a federal abortion ban, which is being talked about right now, or even this partial birth abortion ban was legitimate under commerce, and under Morrison and Lopez, under that jurisprudence.
So glad you asked, because in 2007, I published an article called, Does Congress Have Constitutional Power to Ban Abortion, in the Harvard Journal of Legislation. And I went through it, and I think under the court's precedents, where they're talking about federalism, and if you read Dobbs, this is abortion, it's a contested moral cultural, leaving the states. How does, I think under the court, under Lopez and Morrison, I don't think that Congress would have power. Under my own theory of the Commerce Clause, which is quite broad, I think that if you study, I mean, we both go into, I've studied every act of Parliament regulating commerce, every act of Congress, everything. I'm obsessed. I've been doing this for 25 years. And I think that Congress can regulate. Commerce means buying and selling goods and services and related market-based activity, production, manufacturing, agriculture for sale, et cetera, banking, insurance, et cetera. So I have a broad view of commerce. It's not just buying and selling goods. Right. Thomas is wrong. But if he's right, then abortion doesn't fall into that. Now, under my definition, I'm saying abortion is, among other things, a commercial service. It's the sale of a service for money. It's part of a multi-billion-dollar industry. So I actually think Congress does have the power to regulate abortion. But what I've always said is, it's once it can go either way. Congress could ban abortion, or they could. I mean, and there was a bill in Congress that Biden supported saying we're just going to have a nationwide, and if Congress has power to the Commerce Clause to do that, then they could nationalize it. I mean, I'm not saying it's good or bad. I do think that, I mean, the question is always, well, they're just doing it for a reason other than regulating commerce. But that's always true. True of the Civil Rights Act of 1964. Right. You're eradicating race discrimination because it's evil. You're not doing it as a regulation of interstate commerce, but as long as you're regulating commercial enterprises, restaurants, hotels, et cetera, it doesn't matter what your true motives are. So I do think Congress has that power, but that it's odd that in Gonzalez, none of the justices, particularly Thomas, who has the most restrictive view of commerce, buying and selling goods across state lines, said, well, nobody I feel like nobody briefed it. We're just going to gloss. No. You have to establish the power. So that again tells me that the conservative Commerce Clause jurisprudence is trotted out.
Only when
it's like, ooh, guns, like we're pro-gun and we don't want to stop violence against women. I mean, it's to me, the court was onto something in Lopez and Morrison. They just refused to define what commerce meant. They said, we'll leave it for case by case. But then when, Race came up, we're like,
Yeah.
Congress can get these dope-sucking hippie freaks from the Bay Area, like that. We can't extend Lopez and Morrison where they'd logically extend. Now, to his credit, Thomas said, look, I wouldn't have voted for this legislation, medical marijuana, but, if we say states can have this reserve power, they have the reserve power. So, I mean, it's a good point. Almost nobody addressed that point, and I think it's an important one. And the reason I think it's relevant is that Kavanaugh, in his concurrence, basically Kavanaugh's concurrence was, this is really modest, we're really not doing much, it's neutral, we're just leaving to the states, we're not saying anything, but what he has a line in his opinion saying we're going to leave it to the democratic process, state or federal. He just drops in this line without, footnote, by the way, this is a deeply contested issue, blah, blah, blah. But, I thought that was interesting that of all people, Kavanaugh was the only one who said Congress can regulate this, which I think is politically a dumb thing to say when Congress is controlled by Democrats. That's just me. But I thought that, again, there are all these issues lurking, and the structural issues relate to the individual rights issues, obviously.
No, I really enjoy teaching constitutional law because I love those moments where, the students realize that the court is in a bind, right? So it's race,
right,
when the conservatives are going for this very narrow, pro-state, pro-10th Amendment, very narrow Commerce Clause, but they don't like pot. Right, so they have to swallow that bitter pill.
War on drugs.
War on drugs, right? And so they have to somehow come up with an argument, and which they can't do, which says, they have to come up with an argument somehow, and they're unable to do it, that says there's something different between the war on drugs and environmental laws or the other things, there are other Commerce Clause jurisprudence.
Right.
The liberals are in the same bind, right? The liberals end up in the same bind because they have plenty of situations, and I think Gonzalez versus Carhart was an example of that, where you have a national law that they don't like,
right,
but if they cry foul, then there goes EPA, right? There goes all of their federal mandates that they like.
Right.
So I just love getting the students to see that moment.
Right.
And say, that's the case I'm really interested in, because I just want to see how they're going to thread that needle, both the conservatives and the liberals.
Right.
And Dobbs, in a sense, is that, because they I don't think anybody really wants to get rid of contraception. You're absolutely right. Nobody, conservative or liberal, wants to get rid of it, except maybe Justice Thomas. He said he's willing to go there.
Right.
But the rest don't really want to do that.
Which is why it was solo.
But how do you say we're going to excise Roe, but we're going to leave all the rest of that stuff? And they did it on the basis of this claim of life, this protection of potential life that I just see as an excuse, because clearly they're really not interested in life. They're certainly not interested in human life as it currently.
But in any event, it's not a legal distinction.
No.
Legally, all those cases are on exactly the same
shaky
premise.
Foundation.
But it's a shaky foundation, but the premise is individual rights, personal autonomy, and intimate matters.
Right.
That's it, government out.
And somehow we're going to, I always say that there's sort of three options for what the court's going to do with regard to Roe. There's the nuclear option, which is they're going to take out substantive due process altogether, which means there goes privacy, there goes contraception, there goes same-sex marriage, there goes everything. That's what Justice Thomas wants. Then there's the surgical drone strike, which is you're going to just take abortion out somehow. And the only basis for doing that, I think, that they can come up with is this countervailing right to life, which I'm not saying doesn't exist. I think that's, or there's the landmine option, which is just put so many landmines out there and keep abortion as a fundamental right, but nobody can exercise it because it's so difficult to do. And that's what they've been doing for the last years since Casey or Thornburg, and that's Robert's position. But they ended up doing that surgical, we're going to take abortion out, but we're going to leave everything else intact. And that doesn't satisfy anyone, right? The conservatives aren't happy, the liberals aren't happy. It's just a bad decision, which is why it's wrong. on so many counts. But I think we're running out of time.
Yes, I'd like to open it up to Q&A. if
Oh,
that's okay.